I received word that you would not need Ms. Vallow to appear at this pretrial conference. Is that correct?
She chose not to appear, Your Honor.
All right.
And welcome to Law&Crime Report, everybody. I'm Jesse Weber, and thanks for joining us. We start with Lori Vallow Daybell, the Idaho mother who's facing felony charges in Fremont County related to the grisly discovery of her children's remains on her husband Chad's property. Now, we can't forget that she's also charged with misdemeanors in a different county, Madison County. Those charges: resisting and or obstructing an officer, solicitation, and contempt. Now, in a hearing yesterday, which you just saw, in which Lori Vallow herself chose not to attend, it was determined that the trial on those misdemeanor charges, which was supposed to start in a few weeks at the end of January, it has now been pushed back to August. Let's take a look at that.
I received on December 8th a motion and stipulation to vacate the trial setting in this matter from Mr. Means and Mr. Wood. That was closely followed by the Supreme Court order of December 14th prohibiting any jury trials from occurring until further order. So that essentially also vacated our January trial setting date. And then this morning, Mr. Means, I received from you a waiver of speedy trial with your client's signature. So I hadn't yet vacated the trial date just because I knew this pretrial conference was coming up. I knew we'd need to talk about previous dates, but I will go ahead and vacate that trial date, those trial dates on January 25th now. And then I see that the felony jury trial for Ms. Vallow is currently set for July 12th to continue through August 6th. I mean, it's clear that we're all just making our best guesses as to when we can start having jury trials again based on the COVID-19 orders from the Idaho Supreme Court. I imagine that the two of you would want to set this trial date sometime after August 6th, but let me hear from you, Mr. Means, first on that point.
I would agree with you, Your Honor. After August 6th would work for me.
And Mr. Wood, is that what you're anticipating?
Yes, Your Honor, that would be fine.
So my question is, how much longer after August 6th do you want to set this trial date? I have the week of August 16th available, or the 23rd, or the 30th.
Your Honor, I have a trial on the 19th and one on the 26th. So the earliest I would be available would be the 30th, or the week of the 30th. Looks like it's clear for me.
Mr. Wood, what does your calendar look like?
Your Honor, the dates suggested by Mr. Means would work for me.
So the week of August 30th through September 1st, Monday through Friday, that works for you as well, Mr. Wood?
Yes.
All right. Then I will instruct the clerk to go ahead and set that week for the jury trial.
All right, let's make sense of this. I'm joined today by criminal defense attorney Gabriela Teresa Gonzalez. Gigi, I'm so happy to have you here. And we're going to start with Lori Vallow because there's always an update. There's always something going on. Walk us through why was this decided to push this so many months? And is that the right decision?
Sure. So states all over the country have been pushing back jury trials by a few months as ordered by the state Supreme Court, in order to try to schedule a date where we anticipate courts being closed. Now imagine everyone is trying to figure out when that'll be in the midst of a pandemic where we don't know how every month is going to unfold. So what they're doing is pushing it back with enough time where maybe, just maybe, we are likely to be open and back in court in August versus having a status conference every month, March, April, May, June, in anticipation of going to trial that month. It's a waste of the court's resources. It's not a good use of attorneys' time. So it's better to set the trial date far enough in advance where we're likely to go to trial without having to re-meet. And I'd like to point out that the defendant here did waive their right to speedy trial, which means that the time frame to bring this case to court, to trial, has been expanded. So they've got some time to work with, and it's better to set a date where they can anticipate actually going to trial than to go month by month, seeing if that's the month they're going to go.
And it's also interesting to note that Lori chose not to appear for this short hearing, which was, I think, 10 minutes or under. And it's interesting when you think about this case because there were allegations or rumors that she cared so much about how she appeared during these trial hearings, during these appointments. You know, she put herself together. That was from one of the cellmates. So it's interesting to see that she didn't want to appear. Now, that's a separate issue. You may very well be right, Gigi, about everything you said, but this case is not like every other case. And this is what I want to ask you. There is an overlap between these misdemeanor charges in Madison County and the felony charges in Fremont County. The overlap being that they're both based on allegations that Lori lied to police and encouraged her friend Melanie Gibb to mislead police, and also Lori's failure to comply with the court order to turn over the kids. They're based on these set of what the prosecution says are facts, these allegations. Now we're in a situation where the trial of the misdemeanor charges is going to happen after the trial on the felony charges. Lori is tried with Chad. That's going to happen in July. If that's the way it's currently set, whatever happens in that felony trial, won't that have an effect on what happens in the misdemeanor trial?
Yeah, absolutely. So, it's unlikely that we're going to see these cases be joined, even though it's stemming from similar similar traits and characteristics of the crime. They're in two separate counties stemming from different times. So we're not going to see this most likely being joined. A. B. The priorities in these cases is always going to be the felonies, right? We're always going to try to resolve the felony. And for the state, it's to their advantage because if they're not able to succeed with guilty on the felony trial, then they can fall back on the misdemeanor trial. But if they are able to successfully render a guilty verdict against the defendant in the felony case, then it's likely that the misdemeanor can be either resolved somehow by either, a plea or, some sort of consolidation of the sentencing by taking responsibility, what have you. Either way, it's easier to manage both of the cases by trying the fatter charges first and then moving on to the slimmer things later.
It's interesting that that's what we're going to ultimately see, unless, of course, they decide to move the felony trial, regarding those conspiracy to destroy, alter evidence, if that's going to be moved, as well, if that's going to be moved maybe to the fall of 2021, who knows? But that's an interesting way the timing works. You said something that caught my ear, the joint trial. For a couple that has seemingly been aligned throughout the very beginning of this case and joined at the hip to see on the same page, we saw a little division, didn't we? Where John Pryor, who represents Chad Daybell, he fought to not have his client tried with his wife. This was a hearing from a few months ago.
I think in good faith, I can't argue that the allegations, and I want to make it clear that they are allegations against Mr. Daybell and Ms. Vallow, are similar in nature, and that under the prong of 8B, it applies, and the joinder does apply. The objection, Judge, that I filed talks about prejudice. Further, I appreciate that Mr. Wood recognizes that at any time in the future, I can file a motion for severance under 14 and say that trying these two folks in the same proceeding is highly prejudicial. Mr. Wood and I have discussed, and I'm not going to make a matter of this, but there's still some housekeeping that needs to be done in terms of discovery that Mr. Wood and I are going to privately engage in trying to resolve, and if necessary, we'll ask the court's assistance. But at this point, without all of the information in this case, I'm not in a position to argue severance on this date, and that's going to have to be reserved for a different date. But Mr. Wood's argument, Judge, to suggest convenience to the court and expense to the county and the difficulty of witnesses is secondary. And primarily, Judge, the importance is Mr. Daybell going to get a fair opportunity to present his side of the story? And is it going to be able to be presented without any kind of prejudice or bias? Or are they going to infer anything from any other witness or any other defendant or anybody else that does not afford him an opportunity to fairly present his case? And although 8A doesn't specifically address bias, the Nava case talks briefly that there is still a prejudice or a bias, and the court can evaluate that. Now, I understand there's been an inordinate amount of publicity. Mr. Wood has pointed out examples of of some of the publicity, and I've pointed out examples, and that's going to be reserved for a different date in November when we talk about venue. But the fact remains, Judge, that by linking the two of these folks together is still going to provide a modicum of prejudice. And although I have to concede that joinder, when you look straight at the rule 8A, that there is an allegation of similar facts in this case. The fact remains is what I would ask the court to do is reserve a ruling on joinder, allow the argument to be made in terms of severance once Mr. Wood and I have resolved our discovery issues, and decide at that point whether or not we're going to proceed in a common trial. I don't think it's an effective argument for Mr. Wood to suggest that he's going to have to make more effort and he's going to have to do duplicative work in two different cases. And I'm sorry that he's going to have to engage in that.
Gigi, just sticking on this point, do you think it's fair that they're being tried together? And why did we see this difference where Lori didn't object to being tried with her husband, but you see Chad ultimately objecting?
But those are different strategies by two different defense attorneys representing two different clients. And what's interesting about these types of cases, when you have co-defendants, right? You start to see them, they're definitely unified at the front, not guilty, we didn't commit this. And then as the discovery phase continues, as the defense attorneys start to develop their theories, then you start to see a little separation. Then you start to see this question of, should we be severing? Is it right to join? And, that really comes with learning what the evidence is against the two. And if you've got co-defendants where the evidence, you've got the same evidence for both defendants and the evidence points strongly to one defendant, then when they're tried together, it's not hard to conclude that if one is together, then the other one's got to be in. So, a lot of times co-defendants will be convicted even though they're not as culpable or they didn't commit the crime, but they're sitting next to the co-defendant and they are attached somehow, so they must be guilty.
And we can't forget that both Chad and Lori, they both face these conspiracy charges, but Chad also faces an additional charges of, you could call it evidence destruction, evidence tampering with evidence. Now, I do want to ask you this. We want to preview. Tomorrow's a very big day in this case because the court is going to consider several defense motions. Gigi, a motion to disqualify Rob Wood, the prosecutor, a motion for a change of venue, and Chad's attorney, John Pryor, is going to argue for Chad's charges to ultimately be dismissed. What are you going to be looking out for, and what do you think is going to happen in tomorrow's hearing?
Sure. So when I think about the defense's motion to remove Mr. Wood from the case, they're going to have to prove some sort of prosecutorial misconduct. Mr. Wood, was violating some sort of prosecutorial ethic code. He is biased in some situation. He is unable to, pursue the case and try the case fairly. He's going to have to make that's a very strong accusation to make, and he's going to have some substantial evidence to prove that Prosecutor Wood is unable to prosecute this case fairly. As far as change of venue is concerned, I'm going to be looking for, some sort of issue that arises with the potential jury pool. Has the jury pool been tainted to the point where the right to a fair trial has been completely thrown out the window, right? That's what I'm looking for here. And that's a very difficult standard to meet. We saw that with the Weinstein case, where with that case received international attention. However, they didn't get a change of venue because the jury pool is going to be what it's going to be. So it's going to be really hard for them to get a change of venue here. And as far as the dismissal of the charges, the state's going to have to prove that the state doesn't have the evidence to convict Chad Daybell in this case.
Yeah, and I feel like the change of venue motion might be the strongest one. The Rob Wood disqualification, again, that was all based on allegations that he had inappropriate conversations with key people in this case, and maybe that was not proper. We'll learn more about that tomorrow. A lot of it's been behind closed doors. As far as the charges getting dropped, I agree with you, Gigi. I just don't see that happening. But there's always an update in Lori Vallow Daybell, and there's also an update in the George Floyd case. We'll take a break. When we come back, you have an idea of when that trial is going to start? Think again. We'll be right back.
today's hearing marked another step in what will be a long process toward justice. I thank the Floyd family, the community, and the people of the state of Minnesota for their understanding and patience as we make our case and continue to move forward to a trial. At this time, I'm not in a position to answer any questions. Those of you who know me know that I do answer questions. However, today's court proceeding is a motion to consider motions that have been heard by the court, and therefore I will not comment on them. So that's all I have to say. Thank you.
We move now to the trial of the 4 former officers who have been charged in connection with the death of George Floyd out of Minneapolis, excuse me. You just heard Attorney General Keith Ellison speaking about that. And this was a controversial arrest that was caught on viral video. Clearly, I don't even need to give backstory for this. It's such a major trial, and it's a trial that we thought we were going to see in March, but yet the prosecutors in this case are pushing to have the trial delayed by 3 months due to COVID-19 concerns. Gigi, what exactly is their argument, and do you think the judge is ultimately going to grant this?
So I'll start by saying this. The judge is ultimately going to grant this, I believe. Most state courts, Supreme Courts, have postponed jury trials for a certain amount of months, right? 2 months, 3 months ahead. And what's been happening is, for example, in March 2020, they extended the postponement until July. Well, we know now that that was not going to be enough time to return to courts. So then they extended again to October. We knew in October that wasn't going to work. So they continue extending it 2 months, 2 months, 2 months. Here, we got the last Supreme Court order saying that jury trials are going to be postponed for the next 2 or 3 months. By anticipating a June trial date, you're balancing out the need for public health concerns, right? Making sure that everybody is secure and healthy and maybe even vaccinated before going into closed confined quarters to deliberate what's going to be a lengthy trial, versus the right of the defendants to resolve this issue quickly. Now, a June trial date is not so far in advance that, the trial will not happen speedy, but it is close enough in advance that we can kind of clear out, get an idea of where this pandemic is going to be and more likely return to court at that date versus the March 8th date, which is unlikely that we're going to be returning to court at that time.
Well, Gigi, it's interesting, is it not? Because you see not that many objections. You're not going to see objections from the defense, yet one of the defense attorneys, Thomas Plunkett, says that the timing of the prosecutor's motion is curious because the pandemic has been around for months, trying to suggest, is there another reason that the state wants to delay this trial?
Well, I mean, let's try and work out that hypothetical, right? Has the defense team gotten all of their evidence, and then all of a sudden at the last hour, there's a new witness or a new video? I don't know if that's likely because everyone saw the evidence of the crimes committed pretty much in real time, right? So I don't know if there's going to be any new discovery that's going to make a big make or break difference in this case. I think that it's certainly curious, but I don't think it's so far-fetched. Again, we're kind of at the tail end of where the Supreme Court orders have extended postponements of trials, right? And if in Minneapolis they're following the protocols and they are postponing jury trials, and if March 8th is not looking like the right date, you might as well push it back far enough where it's going to be the right date.
Well, is this an advantage to the defense? You talk about new evidence. One of the things that came out was they did a second search of George Floyd's vehicle. They found 2 white pills that were possibly a combination of meth and fentanyl. They found candy and then an opioid addiction medication. So if you're the defense and you're trying to say that drugs are to blame for the death of this man, or they're also trying to introduce evidence of a prior arrest and saying that he was a bad guy and that police had a reason to apprehend him the way that they did. This delay, aside from the fact that if you're a defendant, you don't have to go to trial, it's less exposure to ultimately the risk of going to prison, you get more time on the outside. the idea, could this benefit the defense?
Maybe it will, but let me tell you what, they could have found a carload of drugs, and I don't believe that their actions would have been justified here. And in this case, you said it yourself, they found the pills after they shoved their knee into the neck of George Floyd for almost 9 minutes, okay? They stopped him and apprehended him because they thought or believed that he used a $20 counterfeit bill. Okay, and that action, that's what caused the police contact in the first place. And that actual action, even if he did do it, even if he had a bunch of fake $20 bills, that doesn't justify the police actions of sticking their knee in his neck for 8 minutes, ultimately killing him.
Well, we'll see what the judge does, if we'll get a trial sooner rather than later. But we do have to move on. I want to move on to another complicated case. This concerns Julian Assange, the WikiLeaks founder. UK judge has blocked his extradition back to the United States, where he's charged with over a dozen crimes, including violating the Espionage Act for his alleged role in publishing classified and diplomatic material. The judge cited Assange's mental decline and possible fear he may kill himself if he's brought back to the U.S., where if convicted, he could face the rest of his life in prison. Gigi, I find this to be a very curious decision from the UK judge. How many defendants out there have, are maybe suicidal or don't love the predicament they're in or in a mental decline? Is that enough reason to not have him go to the U.S. and face those charges?
Let me tell you what, if those cases were decided based on the client's or the defendant's fear of what may happen in prison, nobody would go to prison. No one would go to trial. Okay. So, I do think it's interesting that the UK made that decision. But I was reading a lot that even countries that have extradition treaties with the United States, if the defendant is facing some sort of death penalty charge, they won't extradite them because of the way we treat prisoners here in the United States. So I think that is part of the UK judge's thinking, maybe. But the fact that they cited their decision based on the psychiatrist finding that there's an extreme likelihood of suicide if Julian Assange is brought to trial here, I don't think that's very fair. And I think the United States is going to have a good time with the appeal because they're going to be able to point to Chelsea Manning, who also demonstrated suicidal thoughts and ideologies while they were waiting their trial, and they were able to secure the trial without issue of suicide. So again, we're able to demonstrate that we are able to bring folks to trial, to justice, without them having to kill themselves or actually killing themselves. It happens in the past. We've all seen it. But the likelihood of it happening in this case, especially when we know the defendant has suicidal inclinations, is pretty low.
Well, what steps now does the U.S. government, the prosecutors, maybe particularly the DOJ, we have a new administration coming in, what steps do they take to appeal this and ultimately get Julian Assange into the United States?
Well, they're going to have, in order to appeal this, international abuse. That's a toughie for me, Jesse, but I imagine what they're going to do is they're going to have to prove to the appeals judge that there is not a suicide concern here, that Julian Assange, there's a great interest in being brought to trial here. And, whether he did do it or he didn't do it, that's up for us to decide. He violated laws here in the United States, and he should be brought to face those charges here in the United States. And the United States has a fantastic court system, and we are able to accurately balance Julian Assange's constitutional First Amendment rights versus the enacted legislation that he is seen to violate it. And we have come this far as a country following these protocols. For it to be doubted on such an international scale that's quite a front. And I think that the United States has pretty good standing in their appeal to get him over here. But we're just going to have to find out. And I'm really excited to see what the new administration does about it. We know that the new administration has a completely different philosophy when it comes to their federal prisons and even the death penalty for federal inmates. So that might play a pretty big factor in the appeal.
Could he be pardoned beforehand?
He could. We'll have to see.
I mean, the question is, Because here's the thing, that UK judge was basically said, yeah, we're not sending him over, but she rejected Assange's arguments that this was politically motivated, that this has no basis for him to be tried. So as much as the journalists and the collection of representatives for journalists are saying this is a big win, at the same time, those arguments were rejected by the UK judge, right? It only became an issue of mental health. Could he be extradited? It didn't go into, really hitting upon the or criticizing the prosecution against Julian Assange. And in fact, the judge seemed to signal that President Trump may even kind of sympathize with Julian Assange.
Yeah, big time. Donald Trump definitely sympathizes with Julian Assange. And yeah, I wouldn't have been surprised if, Julian Assange had come in during Trump's administration, if he would have gotten favorable treatment from the DOJ, for example, or if he ended up being convicted, having his sentence commuted or pardoned. It would have been interesting to see that. But you're right. The UK judge based their decision solely on the mental state of Julian Assange. And I wonder, is this going to be up for re-debate later on after he seeks therapy and maybe a course of medications? Is this something that to the UK judge is reversible? And in that instance, will he then be extradited to the United States? I'd be interested to learn that.
Well, look, we're going to go from Julian Assange, whose name is constantly in the news, to someone else whose name is constantly in the news, Danny Masterson. Let's take a break. When we come back, what an update we have for you in his case. Stay tuned.
Your attorneys may appear in court on your behalf without you present.
Yes, Your Honor.
Do you also understand that you must be present anytime the court orders you to be present for any substantive hearing, for any preliminary hearing, for any trial, and for any disposition in this matter?
Yes, Your
The
Honor.
977B waiver form has been lodged and is accepted. Counsel, is it your intention to appear pursuant to 977B at the demur hearing?
Yes, Your Honor.
Mr. Masterson, your attorneys have filed a demur in this case. I have just set a briefing schedule. That demur will be litigated very likely at the next court date. Do you understand that you have the absolute right to be present at that hearing and give up that right and agree that your attorneys can appear on your behalf?
Yes, Your Honor.
And the 977B has been lodged and is formally accepted. That is pursuant to the emergency court rules adopted by this court in early April.
Danny Masterson, the actor who's criminally charged with allegedly raping 3 women, is also facing a civil lawsuit. And that's what we're going to talk about, because a court ruled that all but one of the plaintiffs have to go through the Church of Scientology's arbitration process in order to pursue their claims. The plaintiffs say that church agents attacked, harassed, and threatened them when they came forward with accusations of sexual assault against Masterson, who's a Scientology member. And this result is something that I don't think anybody could have predicted. However, Gigi, I guess if you read the fine print, they could have predicted this might have happened. Explain to us why they have to go through the Church of Scientology's arbitration process instead of going through a court like we all do when you sue somebody.
Yeah. So apparently, to be a member of the Church of Scientology, you have to sign some sort of contract or some sort of agreement saying that you swear to uphold all of the tenets of Church of Scientology. You agree to these certain things. I'm not familiar with the contract. I'm not a Scientologist, but must be some sort of religious arbitration clause that states that if you have any qualms with this Church of Scientology, if you've got an issue or you're trying to seek civil remedy, the way to do it is through religious arbitration. And because they signed that contract, and unless there's some sort of issue with the contract signing, their state of mind or what have you, that's going to be considered binding. So you try to bring in these claims to civil court, the judge is going to see that arbitration clause and say, not here. You guys got to go through religious arbitration. And here they choose, based on the contract, the parties agree that a mediator within the church is going to resolve this. And that's going to be a major issue for these plaintiffs.
Yeah, I don't understand that. I don't understand this. So the church is being accused of wrongdoing, and yet they're going to have their own representative mediator. I mean, is it going to be Tom Cruise? Is that what we're going to deal with? I mean, I would be great. I'm a huge fan of his. But at the same point, is that how this works? How can this be fair? I mean, is the church going to rule against the church?
Highly unlikely, especially when the plaintiffs are accusing the church of the ones harassing them. The plaintiffs here are accusing agents of the church of poisoning their dogs and stalking them and chasing them with their cars, like all sorts of really messed up stuff, right? That they're, seemingly acting on behalf of the church. And now you've got a church arbitrator that's going to decide whether the church's agents' actions were just or unjust here. Doesn't sound fair. And let me tell you what about these religious arbitrations too. They're confidential. You don't have the benefit of a public hearing, right, where people can watch what's happening and watch what's being arbitrated. It's behind closed doors, so we will never learn what happens during that arbitration. And the procedures are relaxed. You don't have those high evidentiary standards to meet. You can kind of just throw out whatever, and the mediator is going to be able to make a decision based on insufficient evidence and facts. So, I don't think the plaintiffs are going to have a very good time here at all. And not to mention, they've got to advocate for themselves against the people that are victimizing them. That's going to be tough for them.
Yeah, we can agree that their claims don't look like they have the most success, but there is one plaintiff, Marie Bobbitt Reales. She can go to court. She can sue Danny Masterson and the church in actual court because she wasn't a member of the church, right? How is that going to play out?
Exactly, because she wasn't a member of this church. She never entered into this agreement that included this arbitration clause. So because she's free from that, she's able to pursue her case in civil court. And there she might have a good time. This plaintiff might be able to seek some remedies here, because now you've got the benefit of having a public hearing with an unbiased judge and a fact finder and possibly a jury. You're going to have a heightened standard of evidence and facts to be admitted to make decisions here. So that plaintiff is more likely to be successful. But again, you're fighting against the Church of Scientology, who has armies of lawyers that are just begging to fight and advocate on behalf of the Church of Scientology. So she's still got a pretty big fight ahead of her too, but she's got a higher likelihood of winning than the other plaintiffs.
Gigi, real quick before we go to our next topic, can any of this have an effect on Masterson's criminal case?
Not likely. These are two separate issues, and luckily for us, the criminal courts don't go through arbitration, so he'll be facing an unbiased fact finder for the criminal case.
All right. Well, I want to move on to another, I don't want to say high-profile entertainment. Yeah, okay, let's go that way. We're going to talk about the Lucchese crime family because John Perna, who is a purported member of this mafia of crime family, confessed that he attacked the husband of former Real Housewives of New Jersey personality Dina Manzo. Prosecutors allege that he did this so that the cost of his wedding reception would be cheaper. Can't make this stuff up. So the state says that Perna, who assaulted Dave Canton with a slapjack, which left him permanently scarred, that he was recruited by Manzo's ex-husband, Thomas Manzo. In exchange for carrying out this attack, Manzo allegedly allowed Perna to hold his over 300-person wedding event at his restaurant at a discounted price, an event that purportedly had members of the Lucchese crime family attending. Now, Perna has pleaded guilty to a racketeering charge, and he faces up to 20 years in prison. Manzo has pled not guilty to conspiracy and racketeering charges that he faces. I mean, Gigi, this is just incredible. What is your reaction to this? Gigi, we have you? Oh, okay, so Gigi is frozen right now, but as soon as we get back to Gigi, I want to ask her this because it should be noted that Thomas Manzo's attorney has said that Perna did not mention his client when he pled guilty to that attack. Let's start there, Gigi. I think we have you back. This man, Perna, never really identified or in public identified Thomas Manzo as recruiting him, but he seemingly confessed to attacking Dave Canton, and it seems to suggest that prosecutors have enough evidence to tie the two. What is your reaction to this first? And then also, how much is this going to affect Thomas Manzo's case?
Well, it doesn't surprise me that Johnny didn't rat out Tommy here. All right. This is a crime family. This man, John Perna, is an alleged handler for the Lucchese crime family. So he's someone who knows his way around the block. He's not going to be just dropping names. If he does the crime, he's going to do the time and come back, with a job waiting for him and maybe even a bonus. So I'm not surprised. I don't think that that necessarily means that Tommy Manza isn't culpable or guilty of the crimes just because Johnny didn't say so. But I think it does help Tommy's case when you don't have someone who is likely going to testify against you that you committed these crimes.
I don't understand, though. Pleading guilty to this, you're saying not the same thing as ratting out the person who allegedly hired you. Because again, he faces could face 20 years in prison, John Perna. Are you suggesting that maybe he's not going to testify against them, that he's not going to give prosecutors, I'll tell you everything about my wedding guests, I'll go through the tape and tell you about each one of them. You're saying that that's not the case that we're dealing with.
Yeah, I'm not sure. You never know with this. Maybe a couple months in federal prison will have him wanting to seek a Rule 35 and start singing to the government. We really don't know that. But here, him pleading guilty to this ultimately puts him in a better position as far as sentencing is concerned, right? Because he's accepting responsibility for his crime. Maybe he'll show remorse. But the judges look favorably on defendants who don't force the government to go to trial and just accept responsibility. And here he's facing 20 years and a $250,000 fine. So if he can plead guilty and get it reduced to maybe 10 years and a smaller fine, that's a great day for this defendant, and he won't have to sing like a canary to the government. Now, if he wants an even bigger reduction, and I don't know about that 10 years, that's just an idea that we're throwing out. It would be a deviation from the 20 years. But if he wanted to reduce his sentence even more from what he was granted, then he would cooperate with the government. And if his cooperation leads to successful convictions of other violent offenders, then he will qualify for Rule 35, which will allow him to seek a reduction in his sentence following that cooperation. But it's always a better bet, sentencing-wise, to just accept responsibility, plead guilty, and let the judge have mercy on you.
Perna's sentencing is set for April 28th, and we'll see what happens between then and then. But the truth is, for Dina Manzo, she's in the middle. She's got an ex-husband who's now accused of orchestrating a plot to attack her current husband. What does she do right now? What role does she play? What happens to her?
Oh gosh, she's in a tough situation, not to mention that her sister is married to Tommy's brother. So they've still got connection to this family. And really it's just a matter of, wow, balancing your emotions, right? Because you were just the victim of, you and your husband were the victim of this violent, aggravated assault and battery, by the hands and the hit of your former ex-husband. And that's a lot to deal with. I think she's definitely in a difficult situation where she wants justice for her husband, but at the same time, she's got her ex-husband's interest in the balance of it, and also to her sister's, future with her husband in the balance of it.
Right.
She's in a tough situation. I do not envy her at all.
And I can just imagine if no one even speaks about what happened, you look at the price that he was charged for that wedding venue and you look at what other people were charged for that, that could be very interesting to see. So if nobody even admits that there was this kind of quid pro quo, you look at just what he was charged, and if that goes to a jury, it'll be interesting for him to explain, or his defense team to explain, why he charged Perna that low rate. All right, we're going to take a break. Our final story concerns a man that we've been following a lot on Law and Crime. You might have heard of him, Dr. Love. We'll be right back.
There are many types of degrees out there that hold the title as doctor, whether they are a physicist or an engineer. Just because someone has the title doctor in front of their name does not necessarily imply MD.
Malachi Love Robinson, or as we know him, Dr. Love. Well, he's back in the news. This is the man who in the past had pled guilty to fraud charges, most notably related to him pretending to be a licensed doctor, and that sent him to prison for over 3 years. And as I said, he's back in the news for all the wrong reasons. Can't say we're so surprised, because now he's accused of stealing money from his employer. That's right, Love Robinson, who was acting as a contracted employee for a shipping broker, is accused of rerouting payments due to the business to his own personal accounts, totaling up to almost $9,500. Gigi, this is, I mean, this is a story you can't make up. What do you make about what he's facing now?
You know, I think his full name is Dr. Love's Fraud, all right? This boy just has it in his blood to scam and use his gift of gab and personality in order to secure funds from himself. And you know, I've got to know, like, who is hiring this man and trusting him with important facts and money. You know, he was able to get the clients from the shipping company to pay him directly instead of the usual, which is to pay the shipping company, and the shipping company gives him his piece of the cut. It's like, how is he able to get this gift of gab in order to convince people to give him the money directly? How is he able to convince employers to trust him with money and with their business? You know, this kid, it's unfortunate, because if he would have directed this in a positive way, he could have been an all-star, but instead he's going to be facing some serious penalties stemming from this fraud case.
Yeah, he's facing serious charges, grand theft and fraud. But here's the interesting thing, right? Didn't he admit this to the police in a series of messages? Because according to the affidavit, police said that they got negative results in trying to get contact with him, but the affidavit says that there were screenshots of text messages in which he says that he effed himself, that he can't say how truly sorry he was, that he doesn't want to go to jail. So he's going to fight this, but yet he seemingly confessed to what he did. I mean, what do you make of that?
Yeah, that sounds like a confession to me. Yeah, if he didn't want to accept responsibility and plead guilty, if he wanted to go to trial on this, his defense attorney is going to have a really difficult time setting those messages aside, because it's very clear that he accepted responsibility for this type of fraud. You know, so it's hard to set that aside. Maybe, just maybe, if he pleads guilty, the judge will be lenient on him on sentencing, but he really did F himself. That's for sure, sending those text messages.
Even if he pleads guilty, let's say he pleads guilty, let's say he's convicted, he fights this, goes to trial, is convicted, his prior record, and again, very similar, his record is very similar to the allegations he faces right now. Could that affect him in getting him a harsher sentence? And what would that sentence look like?
Yes, definitely. First of all, this is a crime in line with his usual habit of defrauding people. They already threw the book at him by sending him to prison for 3 years, stemming from his impersonation of a medical doctor. You know, the court, especially Florida, repeat offender. And what's going to happen here is they're likely
Gigi,
to throw the book at him and throw him the max sentencing. Oh, no, I apologize.
Right.
How about now?
So you said they're going to throw the book. No worries. You said that they're going to throw the book at him. That's possible. But, you know, I'm going to ask you the $1 million question, or the almost $9,500 question, or the $2,000 question, because that's what he bonded out of jail on. The question is, you see all this piled up against him. He's got the gift of gab. He's gotten himself out of other situations. He's going to be there's no attorney of record right now, but if this goes to trial, what possible defenses can he have? Can he say, this is a total misunderstanding? There's a misunderstanding what I wrote in those messages. There's a misunderstanding about where the money was directed. I was just holding on to it for a period of time. Explain us to a quick defense. We have about 40 seconds.
His best defense here, if he decides to go to trial, is going to be misunderstanding. That text message doesn't say that. I have done it a different way.
I'm sorry, you're breaking up. That's okay.
No.
That's okay.
Okay, how about
it's
now?
okay. I think we can all agree, Gigi, that unfortunately for Dr. Love, the circumstances are not so great for him, and people might have fallen out of love with Dr. Love. But Gabriela, Teresa, Gonzalez, for the time that we did have you, I appreciate it. You were terrific. Thank you so much for taking the time to break down all of these incredible cases. Everyone out there, thanks for joining us. We'll be back tomorrow, 12 p.m. Eastern. In the meantime, stick around for our regular scheduled program.